Hello, I'm Philip Rawlings, the Roy Good Professor of Commercial Law at the Centre for Commercial Law Studies, Queen Mary University of London. I'm also convener for Commercial Banking Law, Bank-Customer Relationship on the International Programme of the University of London. As its title suggests, this course deals with the English law on various features of the relationship between banks and their customers. What rights and duties do banks and their customers have? Banking is fundamental to any developed economy. Banks receive deposits, which they lend out, and they act as intermediaries in payments. The first issue we need to consider is, what is a bank? It may be easy to recognise, but rather hard to define. Must a business have certain features, do certain things before we can call it a bank? What are those things? Taking deposits, lending money, acting in the transmission of payments? Since so much rests on them, we might ask why keywords such as bank, banking and customer have never been clearly defined. Why can't we just look at some legislation or case and find the answer? As we'll discover, one reason we can't is that the nature of banking changes rapidly. Just think about the impact of the internet on the way in which we do banking transactions. So, if we establish a definition of a bank, how well will it work in 10 or 20 years' time? This discussion will make us think about what banks do, and it leads us to other issues. The first of these is, what are the terms of a banking contract? These seem relatively obvious. For example, the bank must obey the customer's instructions and mustn't disclose to anyone information relating to its customer's account. But neither is absolute. For instance, the duty of confidentiality has been eaten away by legislation. Governments have taken the view that criminals should not be able to hide their ill-gotten gains, and so banks should be forced to disclose information about their customers. This requires us to think about how far such intrusions should go. When should the police be able to look at a bank account? And that touches on the relationship between privacy, human rights, and state security. The course also looks beyond these contractual rights and duties, because a bank may find itself liable in tort, where a customer has lost money by relying on the bank's expertise. For example, is the bank liable when it gives advice or lends money to a customer for a project that subsequently fails? Banks may also face difficulties if funds pass through accounts that have come from criminal activities. It's a criminal offence to breach the laws on money laundering, which were put in place to attack the profits made from serious crime. This course also discusses money and payment systems. Again, we come up against a problem of definition. What is money? We may believe we all know what money is, or perhaps we just know we could do with more of it. But what is the difference between money in the form of banknotes and money in a bank account? Or between a £20 Amazon gift token and a £20 Bank of England banknote? Is the money in my bank account my money? We might say, I have £100 in my bank account, but if that were true, every time the bank wanted to lend the money, it would need to ask permission from its depositors. Yet if the credit balance in my account is the bank's money, then what do I have? All of this leads nicely into a discussion of payment. Payment can be made in many ways, and it's for lawyers to work out the legal rights and obligations involved. Payment involves parties other than the person paying and the person receiving payment. If I use a credit card to buy a pair of shoes, how does the money go from me to the seller, and what are the rights and duties of the parties? If the credit card company becomes insolvent before payment is made to the seller, do I still owe the money to the shoe shop? What if the seller becomes insolvent and the shoes are defective? Do I still have to pay my credit card bill? A couple of other points. This course doesn't deal with lending. That's discussed elsewhere on the degree programme, although inevitably we do touch on the issue at various points during this course. Also, a knowledge of English contract law is not necessary for this course. You'll learn all you need to know. Banking law is a fascinating area. The legal framework has a very long history, But new methods of undertaking banking business are stretching and challenging that framework. As lawyers, we must be ready to answer the difficult questions that are being posed. The aim of this course is to help you along this road by looking at the underlying principles and applying them to new problems.